2024, an international law enforcement operation exposed a sophisticated criminal pipeline operating between Johannesburg and London. It was not smuggling narcotics or illicit funds, it was smuggling identity. For years, a specific legal vulnerability hidden deep within the immigration frameworks of both the United Kingdom and South Africa has been systematically targeted. It is a loophole that exploits the very laws designed to protect the vulnerable, turning human rights legislation into a multi-million rands backdoor. Today, we are stripping back the political noise to look strictly at the legal mechanics. We will analyze the official tribunal transcripts from the UK Home Office and investigative briefs from South Africa's Border Management Authority. This is the courtroom breakdown of how syndicate lawyers exploit international law and why both nations are racing to close the loophole before their immigration systems collapse. To understand how this international network operates, we must first look at South Africa. Under the South African Refugees Act of 1998, the country boasts some of the most progressive asylum laws in the world, specifically Section 22. Here is how the legal loophole works in practice. Syndicates orchestrate the arrival of individuals on temporary visa or holiday visas. Once inside the borders, the visa expires. Under normal circumstances, this triggers immediate deportation. But that doesn't happen. But legal syndicates exploit a crucial clause. The moment an undocumented individual declares an intention to apply for an asylum, South African law mandates that they must be issued a Section 22 asylum seeker visa. This document instantly legalizes their stay. It grants them the right to work, study, and move freely within the country while the application is processed. Because the Department of Home Affairs faces a massive multi-year backlog of hundreds of thousands of cases, an asylum application is granted. An asylum application is a guaranteed legal stay for up to 5 or even 10 years. But what happens when the application is finally reviewed and rejected? Courtroom records shows that syndicates immediately file for judicial reviews and appeals. In the legal world, this is known as a procedural stalling. The objective is not necessarily to win the asylum case, it is to legally buy time, and that time is used to launch stage 2 of the operation, the jump to the United Kingdom. While South Africa is often the operational base, the ultimate destination for many high-paying clients of these syndicates is the United Kingdom. But entering the United Kingdom directly from West Africa has become incredibly difficult due to strict biometric screening. This is where the South African connection becomes a legal weapon. Syndicates utilize the years spent in South Africa to build a fresh paper trail. They obtain legitimate South African documentation, bank records, and employment history, sometimes through fraudulent marriages and other times through identity theft. With a stabilized profile, the individual applies for a standard UK visa from South Africa, presenting themselves as a well-established middle-class professional taking a holiday. Because they are applying from a secondary country with an established financial history, the UK visa approval rate climbs significantly. The moment the aircraft touches down at London Heathrow, the strategy shifts instantly from deception to international law. Once past the UK border control or immediately upon entry, the individual surrenders their travel documents and claims asylum. Under the UK's Human Rights Act and international treaties, the moment an individual claims asylum on British soil, the UK government is legally barred from immediately deporting them. They enter a strict, heavily protected legal framework. The loophole is officially active. Now let's look at the actual courtroom mechanics. How do immigration lawyers successfully defend these cases when the Home Office tries to deport them? They rely heavily on Article 8 of the European Convention on Human Rights, which is woven directly into UK law. Article 8 guarantees the right to respect for private and family life. In the first higher tribunal, Immigration and Asylum Chamber. The legal battle begins. Home Office presenting officers argue that the individual entered under false pretenses, using a visitor visa with no intention of returning. However, the syndicate's defense lawyers counter with a highly calculated defense. During the months and sometimes years it takes for the UK Home Office to process the initial asylum claim, the applicant is instructed to integrate deeply into the local community. They join religious organizations, volunteer, or father children with a legal residence or British citizen. When the case reaches a judge, the defense lawyer presents a mountain of character references. They argue that deporting the individual will severely breach Article 8, tearing apart a family unit and violating their human rights. In many rulings, judges are legally bound by precedent. If the defense can prove that insurmountable obstacles exist to continuing family life outside the UK, the court is forced to rule against the Home Office, granting the individual discretionary leave to remain. The legal loophole is complete, but a strain on both nations has reached a boiling point. The legal systems are fighting back. In Pretoria, South Africa's Border Management Authority has intensified its crackdown at major ports of entry, deploying advanced biometric systems to intercept fraudulent documentation before individuals can even step foot on the South African soil. The Department of Home Affairs is also overhauling the Refugees Act, aiming to streamline the deportation of economic migrants who misrepresent themselves as asylum seekers. Simultaneously in London, the UK government has introduced sweeping legislative changes. The implementation of the Illegal Migration Act seeks to completely bypass the Article 8 loophole by declaring that anyone entering the UK illegally or under false pretenses will have their asylum claims deemed entirely inadmissible. The battle between the syndicates rewriting the legal playbook and the governments trying to ban it is far from over. Immigration systems are built on a delicate balance. The universal duty to protect human rights, weighed against a sovereign nation's rights to secure its borders. When criminal syndicates find the gaps between those two ideals, it undermines the integrity of the system for those who truly need it the most. As both the UK and the South African tighten their borders, the question remains: can a legal loophole ever truly be closed? Or will lawyers always find a new way through the text of the law? What are your thoughts on how these two nations are handling its specific legal challenges? Let me know in the comment section below. If you want to see more high-profile courtroom and legal breakdowns, make sure to hit that subscribe button. Thank you for watching, and I'll see you in the next breakdown. This is the Hot Seat SA.
Welcome to the fire where the stakes ignite, where the questions burn hotter than the night. No escape once you're locked in the heat. This is your trial.